All right. Well, good evening, everybody, and welcome to the launch of the South African Medico-Legal Reports Quantum Guidelines. And I am absolutely delighted to say that the Quantum Guidelines is now a reality. There's been a tremendous amount of work that's gone into the Quantum Guidelines. We picked up the first of the Quantum Guidelines, first batch from the printers today. Those of you that have ordered the Quantum Guidelines, we will be printing out the full orders where the order will go in tomorrow and will be printed over the next few days. And we are expecting that you should get your books during the course of next week, maybe at the latest the following Monday or Tuesday, but certainly within the next week it will be dispatched. So we're very, very pleased about that. And I personally, I've practiced in this field for those that know me for quite some time, and we've really worked hard on the Quantum Guidelines to deliver a product which is practical, which is useful to practitioners of all stripes. That includes all the way from judges to mediators to advocates, attorneys, expert witnesses, anybody involved in the personal injury field. We believe that the Quantum Guidelines will assist tremendously in your practice in dealing with quantum in an appropriate way. Before we get to, there's a video clip which has been prepared where the interviews held with Herman Edeling and Gavin Roberts. Herman Edeling, a very well-known expert witness and neurosurgeon, very, very interesting interview we had with him. And then Gavin Roberts, who is a very senior personal injury attorney based in Johannesburg that now has his own practice and works a lot with expert witnesses and has a wealth of experience on his own. Two very, very interesting interviews which we did for this launch. The Quantum Guidelines actually come in two versions, and I'm going to show them to you one by one. Firstly, I'm going to show you the version which was sponsored by Rodell Fiduciary. It's actually come out beautifully. I think it really, really looks good. Just a huge thanks and appreciation to Rodell Fiduciary for the support that they've given this project. They've made a significant contribution and really got this project going, and have been fantastic in their support and their patience. And we've gone through a process this year of getting this book right, but we haven't compromised on quality, and I believe that's going to be worthwhile in the long run. So thank you very much to Rodell Fiduciary. I know Rodell Fiduciary have identified certain people that they're going to be sending their version of the books to, and I'll be working with Nicola and Andrew from Rodell on that over the next few weeks. And then there's the South African Medico-Legal Reports, the other version. The text is exactly the same, but the packaging is a little different. This is the South African Medico-Legal Reports version of the Quantum Guidelines. You can see that we've tried to keep the book to a handy and usable and some size that sort of sits well in the hand. It's a funny thing with a book, but a book that is well presented and well put together and sits well in the hand. It just tends to be a book that you use in practice, and we've worked hard with our printers to ensure that we've got the right quality, high quality book, but the right look and feel and weight and paper and everything, text, everything that's gone into this. There's been a lot of thought and experience has gone into this book, and we hope for those that order it, you're going to get a lot of value and that you'll appreciate and get to benefit from all of that insight that's gone into the book. I think I must also, while I'm on the subject of thanking, there's a book like this doesn't happen in a vacuum. This is not just a theoretical treatise where I could lock myself in a sort of university room or something and just research and come up with a book. This book is really a multidisciplinary effort, and it is called on such a wide variety of experts in various fields, right from the judiciary through to advocates, attorneys, expert witnesses, and further. Romeo, there's not an ebook available, ebook version available at the moment. We did look into that, but the ebook software we find is a little challenging. We weren't quite happy with the software, so there isn't one available at the moment. You'd have to buy the hard copy, which is the soft cover, not a hard cover. But we are looking into that, and maybe during next year we'll take on a bit of a project to do the ebook. But as I was saying, this has been a multidisciplinary effort. There's been a tremendous amount of assistance in the background. I don't know whether it comes out in the clips that Che has put together from my interview with Gavin. But there are just so many people who have contributed to this book of all stripes within the personal injury space, and to every single one of you that's made a contribution in any way. Sometimes even people that have attended the intermediate expert witness training course have I've learned so much from interviewing them. People like Judge Donnie Vaderman, who's been an acting judge, and those in Gauteng will be well familiar with Donnie. The work that he's produced, and looking at some of his case reports and the cases that he's done. Herman Edeling has been has been an absolute bastion of support. Carlos de Silva, SC, who's shown so much support. John Mullins, SC, that I've learned so much from listening to him in personal injury space. SAMLR, Sheena, who's here tonight. Sheena, thank you so much. Nicola from Rodel, I see you here. Thank you to Nicola. The whole group of intermediate expert witness, that group was a fantastic group. Romeo, you've been so supportive. Thank you. And then Michelle Posman has also been tremendously supportive in all the projects that I've undertaken. But I must also just make a special mention of two people who really been fantastic in the way that they've supported me in this project, and which really their support is priceless. That's Zita and Che. They've just been phenomenal, unbelievable how they've come through, and I've been able to just leave them to get on with things, knowing, and they come back with a result in both of their portfolios every single time. And so just again, a huge appreciation to both Zita and Che for their efforts. The format we're going to take tonight, we're not going to be long. I'd like to have this finished by about 6:45 or so. And then what we will do is we'll use this evening and the content of this evening to promote the book over the next few weeks and months. And we've got our WhatsApp channels, we've got our usual channels, we've got our website is now up and running, and our current awareness is about to start as from next week. So immediately on the launch of the quantum guidelines. So please just be aware of that and keep your eyes out for that. The idea here is to support practitioners and to help practitioners in their practice deal with the intricacies of personal injury law in a practically effective and implementable way. And we have tried to produce a book that we believe that there's nothing like this in the market, but there's a huge need for it. And it comes really from, as I say, 30 years experience in the courts and speaking to that really very, very broad network and getting input from all those professionals. So that's the introduction. I am going to, in a minute, ask Che just to play the video. And I will then, after that, just take you through the various sections of the book, the various chapters and what is covered. And then we can wrap up. If there are any questions, I'll take those questions for a few minutes. We're not going to spend long on questions. I don't want to make this a very long event. But to every single one of you that's here this evening, it's a weekday. I thank you for your time, and I thank you for your interest. And I always say to people that partake in the resources that I provide, it's a vote of investing in your own professionalism, and you will know that I value that very highly. I believe that professionals in any society, but in particular in South African society, play an absolutely pivotal role and are very, very important to maintaining a good quality of life for all the citizens of this country and anybody else that visits here. So, I'm always so overawed by the stories of professionals that I deal with. So thank you to you all. I will ask Che now to play that video. Che, if you can take over, please.
The user friendliness of this guide giving a wealth of knowledge to not only attorneys, but to experts alike. So if you look how you outline the process, the entire claim process, in a very, very short, succinct, and very nice detail, but backing it up with case law, the relevant authority, which I think is very much lacking in our industry. So I think that if you look at the target market that I would say would really benefit from this, it's not only one specific niche section of the personal injury game. It's going to benefit all attorneys, from newly admitted attorneys, newly functioning attorneys in a new practice, helping them to know what is going to qualify, what's not going to qualify, how do I go about the process, right up to the seasoned campaigners in quantifying the claim and actually saying, how can I challenge the current mindset? And you mentioned earlier about the narrative test, and just for brevity, my daughter's obviously an expert. She's a psychologist, so we have many debates and arguments. And I think the biggest argument we've had over the last year revolves around the narrative test. And if there's any sort of glitch or any sort of, Afrikaans referred to a leemte, a sort of a gap in this entire personal injury market, it comes to the understanding and the application of the narrative test. And why is it critical? And I've been hounding this, and when I went through your guide, it is so nicely set out. I actually can't wait for this to come out, that we can pitch this to the experts out there and to the attorneys that are requesting these narrative tests or sending your client for a medico-legal assessment, and then saying, well, I don't have the 30% WPI, what happens next? And seeing the drivel that is being put out into the industry, in direct contravention of how this thing should be happening. This book is revelationary in that regard. And obviously, someone like myself that goes and researches a lot of case law and that in quantification, your assessment tables are fantastic, with current values, case law. So the absolute thread of case law all the way through in everything that you speak about, from something menial about the delict function of a road accident fund claim or a personal injury claim, all the way through to the assessment, to the narrative, quantification, and then the court's hand-on approach. I think that is gold. A lot of attorneys will say, well, this is my take on it. Yes, but how are the courts interpreting this? And I think that is going to benefit legal practitioners really, really well. It's a really, I'm surprised you fit all of this into the number of pages that you did. And, but the language is not convoluted. It's very modern in terms of how you've translated it and how it's been put down on paper. And it's not convoluted that somebody's going to look at it and say, what is this legal terminology? I don't understand this. So it caters for everyone across the board. And I think it's going to be an excellent reference. I actually want to liken it to, every personal injury attorney has the Klopper book at hand to understand, it's sort of been, and I say this reverently, the Bible for RAF practitioners over the years. I absolutely can tell you that this going forward will definitely be, for anybody in the RAF game specifically, and personal injury game, is going to be really revelation to you. And it's going to be that sort of thing you want on hand all the time when you're going forward and negotiating and settling your claims.
Okay, so in the Road Accident Fund Amendment Act specifies that general damages will only be claimable if injuries are serious. And if injuries are classified as non-serious, then the injured party can't claim any general damages. That brings about the need to determine whether injuries in any particular case are serious. Now, the Act empowered the Minister of Transport to determine the method of determining serious injuries, which is really a medical question. So what the Minister of Transport did was to prescribe the use of an American book called the AMA Guides to Permanent Impairment, which is a book that provides a very complex and detailed method of applying percentage values to people's permanent impairment. So that book is prescribed by our law, by the regulations the minister drafted. And if a person has an impairment rating of 30% or greater under that procedure, then they automatically qualify for general damages. However, there are various shortcomings in that book, in that there are certain types of injuries, certain types of impairments, which cannot be calculated as a percentage for a variety of reasons, which we can go into, but I think at this point, I won't go into that. And because of that, the minister realized that there had to be another method for cases that could not be adequately measured on the AMA guides percentage whole person impairment. And for that, they prescribed an instrument called the narrative test. Now, unfortunately, the narrative test was included very late before the publication of this regulations, and it was taken verbatim from Australian legislation and just put in there. And for any doctor reading that or any lawyer reading that, the words are there, but they're very difficult to interpret because it's such a brief description, and in certain senses, the descriptions are circular and impossible to interpret. So what happened, the HPCSA then started appointing doctors to appeal tribunals to adjudicate when there was a dispute between plaintiffs and the Road Accident Fund about whether particular people's injuries were serious. And I sat on those committees, and it very soon became apparent to us that nobody understood how to apply the narrative test. And the reason being, there was not a suitable explanation of what it was, what its purpose was, how to apply it, or what criteria should be used. So for that reason, I set about, together with the chairpersons of all the committees at that stage, of compiling a document to remedy those shortcomings. And we then agreed that, and we published that document in the Medical Journal of South Africa, the South African Medical Journal, and that was the guidelines to the performance of the narrative test. Now, as much as our guidelines do not have any statutory authority, they've not been approved by the minister or by the department or anything, but it is so. They were published, I think it was in 2012, and now it's 2025, and they've never been challenged. They've often been referred to, and to the best of my knowledge, that is still the only published guideline to how to apply and how to interpret the narrative test in South Africa. So through the test time, that seems to be the de facto authority on how to apply the narrative test. So
now,
just,
Herman, what? Sorry, yeah.
I just want to say, in a nutshell, the AMA guides, which gives a whole person impairment percentage rating, is very good for certain types of impairment which can be measured objectively. So if you lose fingers, it's not as bad as losing 4 fingers. So there's a measurable difference between the two. If you have an amputation, depending how high on the limb the amputation is, or whether it's one or more than one limb, those are measurable differences. They apply very well to most orthopedic injuries. And they also apply, for example, to certain chest and abdominal and like eye injuries. So any organ where the impairment is objectively measurable, like vision or hearing or muscle strength, those guidelines work very well. And so it's a very good system of comparing different types of impairment in a percentage of whole person impairment rating. But where the difficulty with that comes in is impairments of an abstract nature, such as pain, which is not measurable. Impairments such as emotional suffering, which is not measurable. Now, pain and emotional suffering are subjective, but they are very real, and people can become disabled by pain or emotional distress. And it's all very well to say, well, because you can't measure them, they're not real, but that's not true. And think about the principle in law that general damages or non-pecuniary damages are there to compensate for pain and suffering and loss of amenities, that is by its very nature losses which are not objectively measurable. So the narrative test is designed to provide a method of assessment and a method of communication, so that once the doctor has investigated and described it in terms of the narrative test, an attorney, a claims handler, an advocate, a judge can understand. And then the award for general damages must follow effectively from the judge's understanding of how this condition has affected the person's life. That is the principle of the narrative test. A medical expert witness should formulate separately an injury diagnosis and an outcome diagnosis. And what I mean by that, by injury diagnosis, is on the day of the accident or the untoward event or the negligence or the omission or commission, whatever it was, whatever the sentinel event was, what happened on that day? What harm did the person suffer? So it was a hypoxic ischemic brain injury. That would be an injury diagnosis. It was a traumatic brain injury in a motor accident. That would be an injury diagnosis. It could be a fractured femur in a fall from a height. That's an injury diagnosis. So it is the description of the acute injury on the day of the injury. Now, the thing is that when injuries occur, they don't remain in that state forever. The person can die. The person can make a full recovery. The injuries can become complicated, therefore become worse than they appeared at first. They can improve, but never fully recover. So there are a whole range of possible outcomes from any injury. And the outcomes from any injury are unique to that person and those circumstances. So the prior health of the person, the state of resilience, the quality of the treatment, the presence or the access to rehabilitation, the quality of the rehabilitation, the nutritional status of the patient, the mental status, the psychological status, all of these factors have a big role in the extent to which a person recovers partially or well or poorly or fully from any injury. Now, let us start with a fractured femur as a concrete example of an injury diagnosis. And then 2 years later, the bone has united, but the fracture line, which was comminuted, the bone is skew. It hasn't grown on exactly in the right direction, and there's some shortening of the bone. So now that fracture has healed, but the person's leg is deformed and short. So there's a disability because the person walks with a limp, and there may or may not be pain. Now, in that concrete example, it is necessary to determine causation, both in relation to injury diagnosis and in relation to outcome diagnosis. So was that fall from the height the direct cause of that fractured femur? That is normally an easy determination. And usually an orthopedic surgeon will make that determination, and very few people will argue about that. So that is normally straightforward. That is often directly evident from hospital records. But the principle remains. Did the fractured femur come from that fall, or did it come from something else? And did it come from that fall alone, or did it come from a combination of the fall and something else? Those are issues that are considered in terms of causation of the injury diagnosis. Then there's a much longer time span from the injury diagnosis until the outcome diagnosis. Now, the outcome diagnosis is something that should be determined after the condition has stabilized. Now, that status of stabilization is described very well in the American Medical Association Guides to Permanent Impairment, which is prescribed in our law, and that is called MMI, or maximal medical improvement. That means a state where the condition has stabilized and where no significant improvement or deterioration is expected in the next 12 months. So it's not that it's permanently going to be exactly like this, but it is defined in that way. So in medical terms and for practical purposes, the condition has stabilized. That is what is meant by MMI, or maximum medical improvement. Now, when one gets to that point, that is when one formulates an outcome diagnosis. And in this case, the outcome diagnosis can be united fracture with deformity and shortening. And that deformity and shortening is now a permanent condition. And that condition conveys a certain impairment, which is a permanent impairment to that human being. And then in terms of causation, the intellectual exercise for the orthopedic surgeon is, did that injury on that day give rise to this outcome? And was it that injury alone, or was it that injury plus something else? And did anything else contribute to this outcome? Did anything happen in the meantime that interfered with the natural healing? So that is a more complicated determination, whether the injury diagnosis was the cause of the outcome diagnosis.
Yeah.
Now, by considering it in that way, analyzing it and stating it, that accident caused that injury, and that injury caused that outcome, or that injury plus this intervening factor caused that outcome, then to me, the medical expert has done his or her job in explaining to the legal system what has resulted from that cause of action. And the necessity for that is because when it comes to compensation, and this applies both to special damages and general damages, the claim for compensation will relate to the long-term damages caused by that cause of action. And to what extent does that diminish the earning capacity of the person? To what extent does that diminish the capacity to participate in recreational activities? And to what extent does that cause pain and suffering and loss of amenities, etc.?
And one of the things that you do touch on as well that I'm quite passionate about, there where the shortfall is with many litigation attorneys at the moment, personal injury attorneys, is the aspect of contingencies. Now, if you look at in your damages that are awarded, the specific head of damage for future loss of earnings, loss of earning capacity, makes up the vast majority of a road accident fund claim. So that's quantum wise. So attorneys don't understand this, and you see how often somebody will just come and jockey around, well, let's just adapt the pre and post morbids and let's get close to the number that we want. So they fiddle with the contingencies to get to the number instead of actually applying the contingencies correctly. And I have to tell you, I've attended many lectures that we pitched for attorneys to say, this is what contingencies are about, and attorneys do not understand contingencies. You've given such a great, clear rundown of what contingencies are in your guide as well. And I can't tell you enough that the market that you're going to cater for, this is like your other works that you've produced are pretty much based on the medico, that's pretty much focused on the medico-legal expert, and it's for a good reading for the attorney, but not of major relevance because it's more applicable there. This guide would be applicable to everyone across the board. So I think it's an all-encompassing, very detailed and informative guide. And I have to congratulate you. When I started reading, I thought it was just going to be something aimed at the attorneys. We all use the quantum guides, etc., but then you still got to read up on the case and that. But having a breakdown of specific injuries and what you can claim for in relation to what your quantum is based on that, I think this is worth gold, absolute gold. And I really want to congratulate you in how you've put this together. And I can't wait for updates as they go along.
Thank you very much, Che, for that. I really enjoyed watching Herman and Gavin. It's very flattering hearing what they have to say. But, the important point is that this is a reference work to contribute to standards of professionalism within the industry. As I say, I've just drawn on so much, a wealth of experience from people from all sorts of different walks of life. And I just want to, I think that it'd probably be worthwhile just to take you through the main chapters of what the book covers. And I'm going to just go briefly through just in in a short space of time, just talk to you about those chapters. But really the overall work is designed to complement, and it sits in that space. Gavin actually says this in his interview at one point. It isn't in the clip, but he gets it absolutely spot on, where this work sits in the space between sort of the theoretical and the actual hands-on practice in court, or when you're drafting whatever documents. That's what this book is designed to fill, that particular space. And in order to do that, what the book contains is various sections. And I'm just going to take you through that quickly now, the various chapters of the book. Now, there's a methodology to this. These chapters aren't just randomly selected. It's an attempt to take the whole of the field of quantum. And traditionally, it's sort of been divided up into different things. You'll get lists of tables of cases, and then you'll get the actual hardcore theoretical text on damages. And books like what Gavin refers to, Klopper's book, is well known and well used. Koch's book is well known and well used, and there's a space for those books, and practitioners have used them over the years. But there's nothing which brings it all together and which explores certain specific concepts with a particular focus on practice. And so we obviously go through the introduction, and then the first section is general principles of the assessment of damages. And why we put that in is because the general principles of the assessment of damages, that we want to make it easy. Gavin gets it right. It's easy to dip into, easy to understand. We want you to be able to take this out and use it in practice. And that will give you the latest thinking of the judges on a case-to-case basis. And you'll see the various topics that are dealt with, though. We've chosen the most popular and the most important topics to deal with on the general principles, and then the general principles succinctly set out. You'll see, for instance, there's appeals, and then this is still under general principles. Contingencies, which Gavin mentioned during his interview. The approach by the courts to assessing damages. What is the approach by the court? How should the court approach it? How does the court approach it? And then a bit more theoretical, the concept of damages, the various types of damages, delict. So starting from a theoretical base and then building into these very practical issues, such as the approach by the courts, and then on to contingencies, which is so important in any personal injury work. I just want to also make this point that Herman spoke a lot about the narrative test, and so did Gavin. The narrative test, of course, relates to the road accident fund work, but this work is spread wider than that. It applies to any personal injury, whether it's medical malpractice, dog bite cases, assault cases. Any personal injury is covered by this work. We'll obviously focus on certain aspects which come up a lot in practice, and the narrative test in road accident fund work does. So we have a dedicated chapter on that. Then we have a chapter on expert witnesses. Again, we try to distill the main principles. This is not as comprehensive as the expert witness guide, but it gives the main principles and will give a person who's interested in expert witnesses at least the foundational concepts within that chapter. Then we've got the serious injury and narrative test in road accident fund matters. Well, that is what's been discussed there by Herman, with a brilliant synopsis of the use of the narrative test. Really incredibly compelling the way Herman unpacks that. And all of those concepts are then set out and fully considered and applied with reference to case law in chapter 4. Then we've got personal injury trusts here. I must again mention Rodell and their interest. And they were really instrumental in getting this very, very important chapter included in the book on personal injury trusts. If you look at it from a financial perspective, a cold financial perspective, this is important. But to also look at it from the patient and from the human perspective, the administration of personal injury trusts and what happens to the money once it's been awarded is absolutely critical to ensure that it's properly and wisely managed and spent. And Rodell Fiduciary are very, very intimately involved in that type of work. There's quite a bit of content on the personal injury side, in personal injury trusts. Then we get to assessment of specific injuries. So this is this then looks at the categorizations of the various injuries. And the assessment factors, I have to acknowledge the Irish Judicial Council, who've allowed me to use their assessment factors and adapt them to the South African condition, to South African conditions. So we've taken their starting point where they have a set table of assessment factors for various injuries. And then they apply that, and then they put a pound value or a euro value onto that. The euro value is irrelevant. Obviously, we don't take and say, well, if it's worth X euros in the UK, that applies in South Africa. That you cannot do that direct comparison. But what we do is we take their very structured assessment of different types of injuries and the assessment factors which it's recommended should be taken into account. And what that does is it gives a starting point for all expert witnesses, attorneys, advocates, judges, anybody involved here, and mediators as well. Anybody involved in personal injury work, you've got your checklist of factors which should be taken into account. And so one expert can very easily just check, have these factors all be considered by my opponent? Have I considered all these factors? Then that escalates up to the attorney. The attorney, very easy for the attorney to conduct a similar exercise, the advocate, and then ultimately the judge. Everybody can then have a look at what should be considered in a proper quantification of these particular injuries. Herman talks about injury diagnosis and outcome diagnosis. That is a theme that runs through this book. From a legal point of view, it's very important that distinction both of those two diagnoses are done, and it has very important legal and practical implications in court, which is dealt with in the book. But we very much endorse that approach. Herman says it's very important for the medical practitioner to give those two diagnoses. We say it's very important from a legal perspective for different reasons, but coming to the same conclusion. And then we have assessment tables which deal with those various categories of injuries. And I'll just take you through just to that assessment table just to show you how this plays out insofar as the injury and outcome diagnoses are concerned. So here are the assessment tables, and now, so this is the table for pain, 8.1. So it's the first one. There are various award values, how we approach the award values. We will quantify those award values online on the current awareness, quantum guidelines, current awareness work. We will keep sort of a rolling total of those values. We'll add that in over the next few weeks as we discuss the quantum guidelines. These are the assessment factors which I've discussed with you. Various considerations. I'm not going to go into that in detail because time doesn't permit, but I just want to show you that injury and outcome diagnoses. So when we report on a case, we look at both the injury and the outcome diagnosis. We give the name of the case, the award value, and then the adjusted value. And it's this synopsis that Gavin was talking about, which gives you that injury and outcome diagnosis, which allows you to orientate yourself in your research or to give the experts guidance on what should be considered. How has the case, the courts approached these particular issues? And this chapter is intended to be read with the previous chapter, which is the assessment factors. So that really is an overview of the work. I actually should just show you one last thing I think would be of interest. I want to show you how we deal with the principles which are set out. And there's a particular style which I believe is very effective in communicating that type of information. And let me just give you that. So you'll see that the general principles of the assessment of damages, take the first page. So we got 2.1 sources of the South African law of damages. So we look at that. And as Gavin says, in succinct form. And now what is important is that the structure within this book, when we add in terms of the current awareness, if there's a development, say, in respect of the sources of the South African law of damages, we will then note that up with reference to paragraph 2.1. And similarly, the principle of delict as the basis of personal injury claims. If there's reference in the case law, some alteration in the case law or a comment adding to that, we will then cross-reference that to paragraph 2.2, which means that then it would be quite easy to update the hard textbook with what's happening in the current state of the law, and that applies across the whole of the book on any of the chapters that we've dealt with. So that then is an introduction to the quantum guidelines. I'm really looking forward to rolling this out now over the next few weeks and months and over the next year. I see that there were some questions in the chat. Yeah, thank you very much, Shemaine. Thank you very much to Pam Pillay. You're such a wonderful human being, Pam, and thank you for your support. And I've got to know you now quite well, and it's just fantastic. So, to everybody that's been here this evening, I thank you. If you've ordered your books, they'll be on the way shortly, and I look forward to engaging with all of my fellow professionals as I continue to do, and just get richly rewarded for everything that we all put into our practices. So thank you to everybody. I'm going to then close this particular launch. We're at 18:40. I said I'd like to get it done in 45 minutes. I'd like to stick to that out of respect for everybody's time and commitments, but please keep your eyes open. We will give follow-up information, and this is just the start of the project. It's an important first step, but it's just a first step. We will develop this project together with the South African Medico-Legal Reports over the next few months and years. So thank you to everybody, and I hope you have a good evening, and thanks for attending.